Hello, I'm Dana Sparks, broker with Maximum One Greater Atlanta Realtors, and today's contract tip has to do with homeowners associations. Homeowners associations affect both the buyer side and the seller side of the transaction, and can definitely be something worth paying attention to as you get closer to closing and as closings get delayed and extended. This week, we have had two issues with homeowners associations, one on the buyer side and one on the seller side. So on the seller side, we had a transaction that continually got delayed and extended. The closing got pushed into another month, and the seller was required to pay another month's worth of HOA dues. So the seller paid the next month due to the extensions. And at one point, the buyer had agreed on an amendment to prorate that portion of that next month for the seller for the HOA dues. Then the contract got extended again into the next month, went to closing, and that proration for the previous month did not get on the settlement statement and was not addressed between the buyer and the seller prior to closing. So transaction closed, a couple weeks later, and a couple weeks after the closing, that's what I meant to say. And what happened is the seller realized they never got reimbursed from the buyer for that proration of the HOA dues for the month in which they actually closed. So what happened was, as the extensions went on and on and on, the buyer's financial status changed, and which caused the reason for the extensions. The buyer finally did close. The HOA association never sent anything to the closing attorney regarding any prorations or any funds to collect. The closing attorney never put that 1 month's proration of the HOA dues on the settlement statement. And so the transaction closed without the buyer reimbursing the seller for what they had agreed upon in a couple of amendments back. So what do we do? At this point, the buyer does not have the funds to reimburse the seller for those HOA dues that they had addressed. In addition, there were other concessions granted in the additional amendments to extend the closing. So that issue, any kind of any kind of agreements regarding HOA dues, those types of issues do not necessarily survive closing. Remember to go back and look at the contract under which you are binding, whether it be the GAR contract or the RE forms contract, and look and see what provisions actually do survive closing. When you use the special stipulations that are already written for you by an attorney, as you can access in the GAR contracts and in the RE forms contracts, you will see several of them do have that statement, this provision shall survive closing. The seller had plenty of opportunity to review the settlement statement prior to closing and address that issue. The seller did not address that issue. Second issue we had affected the buyer. Buyer bought a house. Got in the contract, there was a copy of the community association disclosure and the fee that was disclosed. And again, this property has closed also. The fee that was collected was one amount of money, and there was a swimming pool and tennis courts on this property too. Get to closing, buyer pays for the base HOA fees, thinking that it was for the entire thing. Buyer moves into the property and then finds out that there is an additional $1,200 fee to join the swimming pool. Imagine that. Buyer has small children, and we are coming up on the 4th of July holiday weekend, and in the height of the summer, that kid probably wants to go and enjoy the swimming pool. So much to the chagrin of the buyer, they now, if they want to do that, have to pay an additional $1,200 to the homeowners association for the pool membership. So how does that affect you as an agent? Well, on the community association exhibit, it did not disclose this additional pool membership money. It just had the base amount for the required membership. The buyer asked the seller if there were any additional fees required, and that's also on the exhibit. The seller said, not to their knowledge. They had never participated in the pool. They never participated in tennis. They never participated in any of those other activities. So to the best of the seller's knowledge, there were not any additional fees because they had not ever paid any additional fees. On the community association exhibit, it clearly states that this information is completed by the seller to the best of the seller's knowledge, and the buyer needs to make themselves 100% certain of all of the fees included, all of the amenities that are included, and everything that is included, including the covenants, when they agree to purchase a home in a covenanted community. Covenanted. Easy for me to say. So, bottom line for you as an agent regarding HOAs, whether you are representing the seller or the buyer in a transaction. Number one, make sure that the buyer does have a copy of the covenants and all of the documents affiliated and assigned and that are part of the homeowners association, including any special assessments that could be pending to that HOA. Number two, please make sure that your sellers complete the community association exhibits to the best of their knowledge. And on the buyer side, please make sure the buyers contact the homeowners association and double check, triple check, make sure they are completely satisfied with what is included, with what base fees, if there are any additional fees for any additional amenities. Second issue, survival of closing. Make sure as an agent that you read your contract and you do know what provisions do actually survive the closing. And number three, make sure that you and your buyers and your sellers completely review the settlement statement prior to closing. A lot of issues that may go unaddressed, as just evidenced in this video, are homeowners association issues, dues, whether they have been prorated, whether they have been prepaid, whether any money needs to be settled up between the buyer and the seller. In addition to that, a lot of homeowners associations charge for their transfer letters and good standing letters and things like that. And make sure you check with the HOA, because a lot of these letters have time frames on them and are only good for a certain amount of time. So if your closing gets extended,